Good evening, Assalamu alaikum. Welcome to the Aman Solicitors live stream. You're watching Basharat Ali from Aman Solicitors Advocates, and we will be starting the live stream very shortly. Just going to start with an opening video. Aman Solicitors Advocates. From our offices in London and Luton, we represent clients across England and Wales. We specialise in civil and commercial law and litigation, divorce, child custody, contact and family law, all areas of personal injury, accidents at work, trips and slips, family and business immigration, nationality, asylum, deportation and detention law, wills and probate, employment law for employees or employers, charity law and disputes, public and regulatory law. Our professional and committed legal team will provide you with a first-class and competitively priced service. Aman Solicitors Advocates, your firm of choice. Welcome to the show. Just a few introductions. This week we'll be looking at a number of issues. We'll be looking at immigration law, wills and probate, education law, particularly with regard to school uniforms and with regard to the punishments for absences. So I'm going to bring in my first guest, Mr. Rahil Latif, my colleague. Are you there, Rahil? Let's just add you in. Just a slight technical issue there. Where are we? Oh, there we are. Assalamu alaikum, Rahil. Good evening.
How you doing?
Very well. So you're going to be talking us through the area of wills and Islamic wills.
That's right. I'm just going to touch upon some key points and slight difference between a normal will and an Islamic will. When I say normal will, I mean a will in accordance with the law of England and Wales.
Yeah. Okay, so over to you then. So you'll give us about a 5-minute or so presentation on what it takes to prepare a will which is compliant with the law of England and Wales, and also Islamic wills also. So over to you, Rahil.
Okay. Yeah, so today I'll be addressing the important topic of preparing a will in compliance with the law of England and Wales. For those individuals who live in Scotland and Northern Ireland, I recommend that you seek advice from a suitably qualified individual in your jurisdiction. I believe that most of us are aware of the importance of having a will. However, some of us may have not been able to draft one as of yet or had the opportunity to do so. Alternatively, some of us may believe that as we do not own any property or have any assets such as a car or jewelry, that there's no need to draft a will. However, I would disagree. With respect to having a will, there are many other benefits. For those who have assets, obviously there's a tax benefit and you can get advice on inheritance tax planning. But for others who have children, then there's the issue of guardianship for your children upon your death, particularly if they're minors, and this is an important consideration, as well as ensuring that there's no disputes amongst your family members upon your death as well. You can make it quite clear, hopefully, who gets what and who's entitled to what as well. So moving on briefly onto the key requirements of having of the will itself. So first of all, a will is required for an individual who is 18 and over. Thereafter, the will should be in writing. It must be in writing for it to be valid. You should be of sound mind, and you should be under no duress or undue influence when preparing the will. So for those of you who have someone else draft a will on your behalf, you should be aware of the content of the will as well to make sure it complies with your wishes. This is quite important. Within the will, you'll stipulate who your beneficiaries are going to be. And what's also important is that you're also going to give an indication or explain who are going to be the executors. An executor is an individual or individuals, up to 4, who are going to comply and set out and pass on your wishes and distribute your assets according to what you set out in your will. What is important for a will is that it's got to be signed, or has to be signed by at least 2 individuals and dated. Now, what is important with this requirement is, with respect to the COVID-19 pandemic, we've had issues of individuals isolating or shielding, or who are too unwell or at risk of getting illness or COVID-19, and therefore are staying in hospital or at home or in care homes. And therefore, due to this, the government have made an amendment to the Wills Act, a very long-standing act, and allowed for the witnessing of the will through video conferencing, such as Zoom, FaceTime. There are certain requirements that have to be met, so a will still have to be signed, ideally within 24 hours, by those who have witnessed it. And when the signing takes place, the other party who made the will can also see that the signature has been made on the actual document which they've signed themselves. This requirement, or this amendment, is going to be backdated to the 30th of January 2020 and is at the moment running until the 30th of January 2022. Hopefully, inshallah, the COVID pandemic will be well over by then, but we'll have to wait and see. So those are key requirements for a will in accordance with England and Wales. Now, regards to a Sharia compliant will, a lot of the requirements I've just mentioned comply with what is required under Sharia. However, one subtle or main difference is about the beneficiaries and those who are going to benefit from the will upon your death. Now, mainly, and the key issue is that you can't really determine who will get what from your assets until your death, because you have to see who are the surviving, or who will be the surviving heirs at that time. So there's a sort of a limitation as to what you can stipulate within the will itself. And for this reason, a certain level of drafting is required within the will to try and cover the issues which are relevant to ensure that your assets are distributed according to the law of Islamic inheritance law. So that's a key issue, and that's a very important part of the drafting of the will, to make sure it's Sharia compliant. There have been issues as to whether or not this will be accepted by the probate court, but my colleague, Mr. Mahmood, has been successful in having a number of wills accepted with this particular drafting in there. And this is something which is to be considered if you wish to have a Sharia compliant will. One other aspect within the Sharia will, you're allowed to leave up to a third of your net assets to a charity or a mosque, for Sadaqah Jariyah, for example, and that's your right to do so. And thereafter, any other assets which remain can be distributed according to the requirements of the Islamic inheritance law. And this obviously just applies once, ideally, all your liabilities and debts have been covered by whatever assets you have, and therefore we're talking about net assets which are being distributed. So primarily, this is the main difference and necessity within a Sharia compliant will. But if you require further information or discussion about this particular aspect, then you can contact us either through the website or by calling us, or through the email itself. So as I said, these are the key issues for the will under the law of England and Wales, and also for a Sharia compliant will.
Brilliant. Thank you very much, Raheel, for that. That was a very nice and helpful summary of the law regarding wills in England and Wales. As Raheel said, if you live in Scotland or Northern Ireland, or if you watch this live stream afterwards, you have to take advice from a competent solicitor or lawyer there, because the requirements will quite likely be different. Certainly in Scotland there will be, and Northern Ireland also has its own provisions. We'll next go to my colleague Saad Saeed, who's going to talk about marriage and visa applications. In the current climate, getting married is difficult, with all the difficulties that you have to go with trying to get a guest list whittled down. But if you're marrying from somebody from outside of the United Kingdom, trying to get a visa and getting your spouse over to this country can be very challenging. And my colleague Saad Saeed will summarize for us the law regarding spouse visas and how you can best secure them. So I'll bring in Saad right now. One moment. Oh, there you are, Saad. Right. So it's over to you, Saad. No, it's not. Sorry, one moment. There we go. Right, Saad, over to you.
Okay, Assalamu alaikum. Thank you very much, Mr. Bashar Ali. Right, I'm going to tell all the viewers today about spouse visas in the form of a story. Okay, so I'm going to draw some of this from personal experience, and hopefully the people listening out there will also be able to relate to it. So, as Basharat said, we're talking about spouse visas today. So the first thing is, back in a few years ago, I was looking to get married. You know, I was of that age. And I happened to get married to somebody who lived in another country. Let's say for the purpose of this story that country was Pakistan. I'm sure lot of the viewers who may be watching may be able to relate to that. So put yourself in my position, if this is you, and listen to the story. Now, so once I got married, I wanted to bring my wife to the UK, and I set about finding out what I needed to do in order to get the visa. So the first thing I was told was to make sure that my marriage, which I'd done, was in accordance with the law of the country in where the ceremony took place. So because I got married in Pakistan, I had to make sure that my marriage was in accordance with Pakistani law. Now, in Pakistan, I had a normal wedding. I had a nikah ceremony, and this was registered. And I found out that the day that it was registered, then that was the day that my marriage took place under Pakistani law. So I had no problems there. I had my nikah certificate. I had my registration certificate from the authorities. And I was told that's all I need, and that's fine. So I submitted those with my application. The next thing I had to do was I had to make sure that I was earning enough money to be able to bring my spouse over. So I checked the amount. I was told it was £18,000, 18,600 per year that I had to be earning. And I was told I could meet this in a number of ways. Now, at the time, I was working for a company. And as an employee, because I'd been employed by them for about 3-4 years, then this was perfectly fine. And I checked that my salary was enough, which was fine. And I had to submit bank statements. I had to submit my pay slips. I had to submit my contract of employment. I was also advised to submit my P60. And I had to get a letter from my employer to confirm all of these things as well, how much I was earning and since when, and that I was employed by them. So having got those documents, I found out that I met the requirement for the visa, and I submitted those documents along with my application. The next thing I had to do was to show that I had enough accommodation to live in. So when my spouse came to the UK, the property in which we lived in wouldn't be overcrowded. So again, I inquired about this, and I found out that my property was suitable, because I was told that generally the rule is that 1 bedroom can accommodate 2 people without being overcrowded. Now, at the time, I was living with my parents in my parents' house, and I wondered whether this was a problem. But because we had 2 bedrooms, so one for my parents and one for me, I was told that this was perfectly acceptable. So my parents could have 1 bedroom, me and my missus could have another bedroom, and the property would not be overcrowded. Now, I was also told to obtain proof to show that the property wouldn't be overcrowded. So I asked whether the documents showing ownership of the property were enough, and I was told no, they're not. And what I had to do then was actually to get a survey done to show how large the rooms were, to show exactly what rooms I had in my house, to show that I had a living room as well, and a kitchen room, and a dining room. And then somebody wrote a report to say that the property would not be overcrowded if me, my wife, and my parents lived there. So those documents showed that I met the accommodation requirements, and I submitted those with my application. Then I found out that my wife had to be able to speak English to a certain level if she was to get the visa to come to the UK. Now, the level was not high, and I was quite lucky that my wife already spoke English, because being from Pakistan, many people do. But what I did find out as well is that even though she had a degree from a university in Pakistan, this is not accepted necessarily to show English language, because when you have a degree from another country, what happens is there's an organization called NARIC who tell you whether the level of English in that degree is the required level to meet the requirements for the visa application. And in many countries around the world, degrees from various countries do not meet the requirement. So then my wife had to actually undergo a separate English language test to show that she met the requirement. There was a list which the Home Office produced of tests which they say are the ones which they will accept. So I had to make sure that my wife took one of the tests which was on that list. And obviously she passed it very, very easily, and she got the certificate, and then we met that requirement as well. Right, now then I was also told that within 6 months of when we submitted the application for the visa, I had to make sure that my wife undertook a TB test, and that TB test was clear. And again, I couldn't go to any old clinic just to do that. I had to look on the Home Office website and check which clinic was authorized for that. So I did that, found the appropriate clinic. My wife took the test, and obviously she passed. And then the last thing I had to do was check that my wife met the suitability criteria. Now, what are we talking about here? Well, basically, we're talking about crimes and criminal behavior. So, in a nutshell, you have to make sure that your wife or your husband, whoever's listening out there, is not an axe murderer. That's right. So I checked that she hadn't killed anybody, at least not at that point. I'm sure from some of the arguments we've had since then, she's felt like killing me. But yeah, there are suitability requirements. You have to make sure that your spouse hasn't committed crimes abroad. You have to check that in previous applications, they haven't been refused because they've lied or made false representations. And things like that. And obviously, with my wife being an innocent person, being quite clear, having a clear record, there were no problems there. So we met the suitability requirements. So then I submitted all of these documents, completed my application online, sent it off, paid the relevant fees and immigration help surcharge, sent it off to UKVI. We waited around 12 weeks, and then eventually we got the decision and she got the visa. The happy ending to this story is obviously that my wife came to the UK. Since then, we've been living happily ever after. Well, I say happily ever after. You know, I mentioned about her wanting to kill me on a few occasions, but then what spouse doesn't? So yeah, she got a visa for 2.5 years initially. In 2.5 years' time, or I think we're coming to the end of it. So in about 6 months' time, we will have to apply for an extension for another 2.5 years. And then I've been told once my wife completes the 5-year period, so 2 lots of 2.5 years, then she'll be eligible to apply for settlement. So we're looking forward to that day. I hope the viewers have enjoyed the story. I hope some of them have been able to relate to what I've said. And if you're in the same boat that I am, and you have any queries or questions, it's very, very important that you make sure before you do anything that you are doing the right thing. So it's always very, very important to make sure you seek legal advice, because what I noticed when I made my application was that there are very, very subtle nuances in the rules. Some things can be accepted and some things can't, and sometimes you fall on the wrong side of the rules, and if you do that, you risk that your application is refused. So it's very, very important for everybody to check that they make sure they meet the requirements properly. That's my story. I hope the viewers enjoyed that. And if they have any questions, by all means, I'm here to answer them.
Thank you very much, Saad. Coming back to you, one moment. There we are. So thank you very much for that. That was my colleague Saad Said. No story like a love story, and that was one, hopefully, that they will live happily ever after, and long may it continue for whoever it was. Just in case Saad's wife is watching, he hasn't got a second wife. He's talking about a client. So he'll get a pass today. Now, what we're going to look at next will be the story of Siham Hamoud, which raised the issue of school uniforms. This is, of course, the story of the young girl who goes to school in Uxbridge, who, having gone to school for many years, it's said in the newspaper article, all of a sudden was asked to go home and come back with a shorter length skirt. So the school basically took the view that, to read you from the actual newspaper before I go into the law, the parents of a Muslim girl who was sent home from school for wearing a skirt that was deemed too long are being threatened with legal action. Now, this girl, as we've said, had been going for many years to this school. Her siblings had gone to that school, older sisters included, who also wore such clothing. Now, in this context, her father, Siham's father, Mr. Idris, he's explained to the newspaper, The Guardian, the article that I'm taking this from, that the child has very strong and devout religious beliefs, and therefore she refused to go back. From the purpose of the person who sent her home, they would have thought, well, just change into a skirt and come back, not being sensitive or aware of the religious sensitivities in this case. And so what happens is that the girl stays at home. She refuses to go back, so the article says. And now the school are basically threatening to take legal action against the family because they're not forcing, the parents are not forcing her to wear a shorter skirt. And as it's quoted in The Guardian, to quote, the father says, it is her faith and her decision to make. She used to love school, but now she goes to school crying because it's heartbreaking. So in this context, the school wrote a letter, and the Guardian quoted this, that Siham's absence is being recorded as unauthorized. Unauthorized absence may result in a fine being issued or legal action being taken against adults who have parental responsibility, i.e. parents or those who are discharging the parental responsibility of day-to-day care. And this is how the matter has now stood. So what is the law? There is no primary law or an act of parliament or anything like that regarding uniforms. The guidance that's given is what's called extra statutory. It's basically general guidance given in the capacity of helping the schools. And the school governing body, the body that manages the school, is responsible to make a decision. First of all, do they want a school uniform? They don't have to have one. If they do, then what is the form of the uniform going to be? And they must, in this context, consult and review what the situation is, notify the people concerned both at the school and then those who will be affected by it. So parents of children and children, so they understand what is going on. It's about consulting those people who will be affected by it. So this could apply to any school, whether it's a state school or what's called an independent school, a private school. There is a duty to consult if you're going to have a school uniform policy. And once you've decided what it is, you have to take account of everybody's basically sensitivities on this. Once that is done, the school uniform policy must be reviewed regularly. And it says once at least every 5 years. So this is where the school, having gone down that road, they are required to review. And or if a parent or parents ask the school, look, we want you to review the uniform policy because our child has a particular need or a requirement, and we want you to take account of that. And the law says that basically what should happen is that the school should take into account religious belief, social, cultural background, amongst other factors, when they're deciding what the school uniform policy should be. So in a case like the one we have in say, Uxbridge, where other children were wearing this uniform, even indeed the girl's siblings had been wearing a similar length skirt, then it is for the school to actually make due allowance for that. They've got to listen to the concerns, they've got to listen to what's being put out, and then on the back of that, the school should try and accommodate. It's not about my way or the highway. It is about looking after the best interest of the children to facilitate children learning. And if you come to a situation where, as in this case, it appears the school is not willing to accommodate, then you have to now go to the next level, which is that the school is going to have some sort of disciplinary process. And that disciplinary process will require the school to actually listen to the arguments and the submissions put forward on behalf of the child, and then make a decision which has the whole idea that the children should be educated in an environment which is helping them to facilitate their learning. If you do not resolve the matter at the school stage, there are potentially further appeals, and if that doesn't work, then of course the case can go on to what's called the High Court by way of a judicial review. I mentioned about penalties and sanctions because if the school does not authorize the absence and you don't have any other lawful reason, there are a number of lawful reasons why a child can be excused from attendance at a school, then you can be issued a fixed penalty notice, rather like a parking fine or a speeding ticket. We're going to fine you £60 if you pay within 21 days, and if you don't pay within that time, then it's going to be £120, and then there are onward measures if you don't pay. Or in the alternative, a summons can be issued. You could be potentially prosecuted for unauthorized absences of your child from school because you're not compelling your child, in this case, to wear the right uniform and come to school. And if that happens, then potentially you could have criminal sanctions against you under the Education Act, which would then result in a magistrate's court case where you would have to argue. Now, the law is quite clear. You remember a few years ago when somebody took their children on holiday and said, well, my kids are attending school regularly. Well, that case lost in the highest court in the country. And if your child is not attending without any reasonable excuse, then that's unauthorized absence, and you would be guilty, could be fined. In a worst case scenario, if you disobey, it could be worse. So it is worth taking advice regarding these matters. If your child is affected by a uniform policy, take good legal advice and then try and negotiate with the school. It's never a good idea to go in confrontational. At the end of the day, your child has to attend this school, and therefore you should try and work with the school. Whether it's an independent school, that is a private school, or a state school, the rules are very much similar. The law is very much in accordance with that. And if things don't work out, then take sound legal advice. Do not risk getting a criminal record. Do not risk getting unnecessarily fined and so on. That is the law regarding school uniforms. Now, we are hopefully going to be joined in a moment by our other colleague, Adnan Mahmood, and then he will talk about probate. In the interim, or in the meantime, we are, oh, here we are, speak of the man, and he's arrived. So I'll bring him up, and then we will all leave. Assalamu alaikum, Adnan. Thanks for joining us.
Alaikum salam. How are you?
I'm very well, thank you very much. Oh, you've disappeared.
Oh, sorry, just bear with me.
We've lost your...
Slight
we can't
technical
see you.
issues.
Oh, there we are, you're back. Right, so thanks very much for joining us. Now, what we want to know is, what are you going to talk about this evening?
Okay, well, today, inshallah, I'm going to talk about probate. I'm going to cover the process for dealing with assets that are left behind by a deceased, and what happens if they don't leave a will, and what happens for delays in making probate applications, such as inheritance tax penalties. For those who don't know, probate is essentially a term which is used to describe the administration of an estate. It's basically, once somebody passes away, it's the process of gathering all of the assets together and then distributing them in accordance with the deceased's will, or if they died without making a will, in accordance with intestacy laws. Intestacy is basically the laws of the land, which is when I'm apologies that I missed the start of the show, but I'm sure Raheel probably covered the issues of wills. The intestacy law deals with it deals with assets. When somebody passes away without having made a will, English law will dictate exactly how those assets are distributed. Now, those may not be in accordance with somebody's wishes, so the deceased wishes. I'll give a working example. It could be, if somebody dies leaving a spouse and children, then the way the asset is split is that the first £250,000 of the estate is given to the spouse. The remainder is then split in two, where half goes to the spouse and the remaining half will go to the children in equal shares. That's it. That's pretty much what intestacy law will provide for in such a specific scenario. So yeah, I will be mainly talking about the issues of probate.
We've lost you again.
Sorry, I'm not sure if you caught any of that.
No, we call all of it. You all got everybody on. So it's back to you. Over to probate then. Do you want to say? Do you want to share some more thoughts with us about how the process works briefly?
Yeah. Okay. So probate. When somebody passes away, it's natural that the family want to be concentrating on bereaving the deceased, and it's not, it's not really their primary concern of how to deal with those assets. So generally, they will instruct solicitors to deal with the administration of the estate. And like I said, that process is known as probate. Probate essentially means, in order to get the assets of the deceased transferred into the names of the beneficiary, certain processes need to be followed. Those processes involve getting a grant of probate, which is effectively a document which is issued by the probate registry, and then using that grant to then transfer property, whether it's freehold property, leasehold property, releasing funds from bank accounts, from transferring shares or stock options, or even dealing with foreign assets. So that process is known as probate, which is where you obtain the grant of probate, which is an official document obtained by the probate registry. That process in itself involves a number of steps where usually solicitors will get involved and help go through the process to alleviate that burden of dealing with that process for the deceased family, while they can concentrate on bereaving. The process in itself can take about 6 months, and then there are, as part of that, inheritance tax accounts need to be filed. A lot of people are concerned, naturally, when somebody passes away, about the risk of the estate being subject to inheritance tax, which is a very heavy tax. I call it a tax where effectively a deceased is essentially chased to the grave. the government will charge 40% on any estate for anything above £325,000, which is a whopping amount. So say, for example, somebody has an estate of, say, £500,000. The first £325,000 of that is tax-free. It's known as the nil rate band. But the remainder, which is £175,000, is taxed at 40%. So part of the procedure is in obtaining probate is to file inheritance tax accounts, which HMRC will then sign off. And obviously your probate practitioner will ensure that any inheritance tax exemptions are applied in order to minimize the risk or minimize the amount, or even, potentially even eliminate the amount of inheritance tax which is payable. There is a time limit. Or any inheritance tax that has to be paid must be paid within 6 months. All in IHT accounts must be filed within 12 months. So the clock is ticking. And at present, unfortunately, because of the COVID pandemic, there have been over nearly, I believe yesterday's figures were 89,000 deaths in the UK. This has had an overwhelming effect on the probate registry, which basically means now that the probate registry's processes of issuing that grant of probate are very much delayed. Before the pandemic hit, the probate registry was already struggling with a backlog, and now having to deal with so many extra deaths, it's caused a massive delay. So it's important for the family of the deceased, when they are administrating an estate, I'm sure Rahul would have mentioned the term executor, the executor of the estate, or the personal representatives of the estate. It's important for them to ensure that they act quickly, given the delays in the probate registry now, especially when there is a time limit in order to pay any IHT liability or inheritance tax accounts. By way of example, I recently was dealing with a case where the spouse of the wife of the deceased left shares, a massive amount of shares, over £250,000 worth of shares, which had a stock option which needed to be exercised within the first 12 months. And if after the 12 months, if the grant hadn't been obtained, then there was a risk that those shares would have been lost. And the probate registry, with its delays, it was taking too long. In a case like that, it was extremely important, like what we did, is ensure that the probate application, the processes are done quickly and swiftly, and then pressure put on the probate registry to ensure that the grant of probate is given in time. Thankfully, alhamdulillah, we managed to get it and in time, and we managed to sort out those issues of the shares. So in a nutshell, the process involved, as I said, is known as probate. It involves, number one, valuing the estate. We're finding out how much is it that the deceased has left behind. Number two, it's about filing the inheritance tax accounts, paying any IHT that's due. Number three, it's then about obtaining the actual grant of probate, without which you can't actually transfer any property. You can't transfer certain sums within bank accounts, because banking providers will require for a grant of probate to be provided before they release any money. And then once a grant of probate has been issued, then the final part is the distribution, where you call in all of the assets and then you distribute in accordance with the deceased's will, or as I said before, if the deceased did not leave a will, then in accordance with the laws of intestacy.
Perfect. Thanks very much for that, Adnan. So let's get back in. We'll all join you. Where are we? I'm trying to add everybody in. 1 second. All right, there you go. Everybody's back. That was a very good discussion. Just want to pick up a couple of key points here. So let's come to you, Rahil. In terms of the process for making a will, and Adnan, of course, both of you could help with this. How long would it take if, say, I wanted to make a will, whether it's an Islamic will or otherwise, I called the office tomorrow and said, I want to make a will. How soon could it be turned around, and what sort of problems, in your experience, delay things? Rahil, Adnan?
Adnan,
Don't jump up together.
Yeah. Drafting a will can be as simple as somebody walking into the office and then at the end of the appointment on the same day, then walking out of the office with a fully executed will. It really depends on how clear the instructions are. If somebody is clear, this is what they want, this is how they want to distribute their assets, then it's clear for us. We can prepare, or most solicitors will be able to prepare a will within the same appointment.
So what do they need to bring with them? So what would I need to bring with me? So just rattle through a list of documents.
So if you came to me and you said you wanted to make a will, I'd say, right, firstly, I need to confirm your identity. I need to make sure that you are in fact Basharat Ali if you claim to be him. I need to see your proof of ID, proof of address. And once I'm satisfied that you are indeed Mr. Basharat Ali, then I will be satisfied that I'm dealing with the right person. And then your instructions. Well, ideally, what we would do is we'd send out a wills questionnaire to you in advance, which gives you things to think about before actually attending the appointment. So rather than coming dumbfounded to the appointment, not knowing where to start, you'd have an idea beforehand of terms such as what is executor, what are the key requirements of a will, whether or not you need to have a specific guardianship clauses for your children, etc., etc. And
okay,
if those instructions are clear, then the will can be prepared, and subject to there being 2 independent witnesses available, they could be prepared there and then on the spot. Could be executed there and then.
Okay, so it can be a very swift process, and if there are any complications, you would advise, and then obviously they would take. You mentioned tax and inheritance tax, so anything like that where there's a large estate above the threshold, you would then suggest that they take independent tax advice so as to lawfully make use of tax allowances and laws available whereby they could lower the amount of tax they'd have to pay rather than avoid, because tax avoidance is evasion is illegal. Lawfully making provision which minimizes it is lawful, right?
Quite right. It's known as tax planning. A lot of people are under the misunderstanding that a will be able to eliminate any tax. It doesn't do that. What a will does is it ensures that your wishes are set down in stone in written form for your executors to ensure that your assets are distributed how you want them to be distributed. So the will doesn't actually have the effect of trying to save tax. Trying to save tax is done through careful tax planning throughout your lifetime. There are certain mechanisms that can be put in a will, such as a trust, etc., which can sort of help reduce the amount of tax that the estate may be liable to. But yes, we would certainly advise, if somebody has a complex estate, if they require more detailed tax advice, that they definitely seek the services of a professional tax advisor.
Okay. Regarding the issue of the love story from abroad, Saad, in terms of these marriage applications and when people are smitten by love, what are the sort of common pitfalls in your experience which people should be alert to before they make an application and then have to, cry tears of blood when they're parted from their loved ones? Yes,
well, thank you for that. So in my experience, the 2 biggest pitfalls that I see most often are either where marriage ceremonies aren't conducted properly, in accordance with the law of the country, or where people either don't meet the financial threshold or provide the wrong documents. I'll talk about the financial documents in more detail because this is really the biggest reason for refusal in my experience. So under the immigration rules that we have, depending on whether you're an employee or whether you're self-employed or whether you're a director of a company or whether you're relying on savings or other kind of income, the rules stipulate specified documents that have to be provided in order to meet the financial income requirement. And what happens is that you may have a list of 4 or 5 or 6 documents depending on what your income source is, and a person may be missing 1 or 2 of those documents, and they may think, well, it doesn't matter because I've got most of them, so I'll just submit them and it will be okay. But what the rules stipulate is that if a document is specified, it absolutely must be provided. And this is really, I think, the biggest pitfall that I've seen most applications are refused on.
So missed by a meter, missed by a mile. There's no what's called a discretion in these things. Either you meet the rules or you don't, and therefore get these documents checked to make sure everything adds up. Okay.
That's correct. Yeah.
And you mentioned another one. So the lawful marriage here is that where people go and get into religious marriages or some sort of cultural marriage, which hasn't been registered with the equivalent of the marriage registry or the registrar of births, deaths and marriages, like in this country. So, when people go to the civil registry or go to a religious institution which is licensed to perform marriage ceremonies under the law, this is where the problem is. So they may go to a village or some, even in a town, but do a religious marriage, but not have it registered, and therefore it's not valid under the law, and therefore will not be acceptable. Is that what you're saying?
Yes, that's correct. So let's draw an analogy between, like you said, what happens in the UK. So over here, lots of Muslims, for example, will have a nikah ceremony with the imam, maybe in a hall or in their home or in a nice hotel somewhere. And under the eyes of the law of the UK, that is not considered as a legal marriage. So when a couple have a nikah ceremony, they are not considered married under the eyes of the law. They're only considered married under the eyes of the law here once they go to the registry office and once they register that marriage, which can obviously be at any time, at any point in time. And you'll be surprised at how many other countries have a similar system. Even countries like Pakistan, countries like India, countries in the Middle East, they have a system whereby the nikah ceremony in itself may not always be recognized as a legal marriage, and it has to be registered either at a union council or at a court or other official organization. And it's only when it's registered with that institution that a couple are considered married under the eyes of the law of that country. So it's very, very important everybody checks that they get properly legally married in the law of the land where they have the ceremony.
Okay, and Rahul, coming to you, I mean, many people, when they think about Islamic wills, they think Islamic laws and rules, and that's not necessarily the case, because the law regarding the validity of a will under the law of England and Wales is what must be satisfied, but you can express your wishes about how you wish for your assets to be distributed after your marriage. So you can stipulate, I want to follow the Hanafi fiqh or the Hanbali or the Maliki or the Shafi'i or whichever fiqh or that's school of jurisprudence that is in translation. Is that right? So there's two parts: meeting the legal requirements under the law of England and Wales, and then you explain which Islamic viewpoint you want to follow. Is that right?
That's right. Ideally, under the law of England and Wales, there should be clarity in the will itself, so that it should ideally preferences for them to make clear who are the beneficiaries and what they will get. And that's where there can be a slight problem with the Islamic will in terms of how you can convey how you want your assets distributed according to particular madhab or in terms of the law of inheritance law under Islamic law. So we've had several cases overseen by Adnan where the will has been accepted, where there's been these certain clauses in there which has fulfilled the wishes of the individuals themselves. So there is a way of drafting a particular will to meet both requirements.
Right. So the key thing, you mentioned the word clarity. And of course, the way Islam works is that it's who is alive at the date of the deceased having died that then determines who inherits and what they inherit. So we know algebra came down on the basis of trying to work out formulaically how inheritance would take place Islamically. So that's very interesting. I mean, coming to you with regard to the probate registry, clearly you have good and bad type of scenarios. What happens, let's say, person, Abdullah and Maryam, they leave a will. They want the Sharia to be followed, but some of the kids say, no, I want the law of the land. I'm not going to accept Sharia law, whatever. Or some do, some don't. In that sort of a scenario, what would happen? Presumably the courts are going to decide, or does the deceased will take precedence if it's clear enough?
The deceased will always take precedence because that was the wishes of the deceased. It's the deceased estate. It's not the estate of the children. So whatever the deceased has expressed within their will that should be followed. Having said that, however, there is in English law an exception where all of the beneficiaries, if they wish, they can enter into what's called a deed of variation, where they can vary the distribution terms of the will. So if the beneficiaries collectively say, no, we don't want to follow the wishes of the deceased, we, however, have collectively agreed that we want the assets to be distributed in, say, X manner.
Whatever way, yeah.
Yeah, so then what would happen is that they would need to enter into a deed of variation. There is a time limit to do that. It's 2 years from the date of death. So after 2 years, if they don't enter into deed of variation, then time's up. Then the deceased's will must be followed. But I'll make clear is that this is only if all of the beneficiaries agree. If they don't agree, then the deed of variation cannot be entered into, and the wishes of the deceased must be followed to the letter.
And let's take an example of a very egregious father or mother who shut out somebody who's dependent upon them, i.e. they were living with them, and towards the end, whether it's dementia prior to it setting in or some sort of, it is not uncommon, people do fall out for whatever reason, and they cut somebody who literally was dependent upon them for years and possibly lifetime. Now, both Islamically, what's the position, and what's the position under English law? If somebody is a dependent and they were necessarily dependent upon you, would they be able to challenge being cut out because they have no other option?
Well, the two issues there. First point is Islamically, the rules in relation to Islamic inheritance are very clear. Allah has made them very clear in the Quran, and more so than many other rules. And they must be followed. And if somebody has, if a testator, the person who makes the will, who then subsequently dies, in their will they seek to cut somebody's haqq, their right under Islamic law, out, then ultimately that's something that they will need to be answerable for when they, on the day of judgment. That's a matter for them. If they do, however, do it, the second point, if they do, however, do it, then English law will dictate that the deceased's wishes must be followed. However, if that person who they've cut out is somebody who was financially dependent on them, then there is legislation available providing for inheritance provision given to somebody who was a dependent. And there are certain procedures which would need to be followed, which may necessitate the requirement of a court application to make sure that that person who's been cut out is entitled.
Thank you for that. And Asad, coming to you, so once upon a time in Pakistan, the love story continues. You made the application, you got a good solicitor, and somebody who's had a bad day at the office has basically overlooked or just refused you unreasonably. Or in the case of unreasonable refusal, you presumably have to go to the courts for appeals. Now, how does that work, and what sort of time scale is involved in these appeals? Excuse me.
Yes, that's a good question. Yes, so look, if I hadn't sought the right legal advice, or if I was missing a document, as we said, or if my application was refused for any reason, whether it was reasonable or unreasonable, I will have the right to appeal to what is called the first tier tribunal, and I will normally have 28 days from the date that I am given the decision to appeal, to lodge my appeal. So as things stand at the moment, yes, everybody will get a right of appeal to the first tier, where they can then go and they can present their case in front of a judge, and they can say to the judge, look, this is why the decision to refuse my application is wrong. So the Home Office have decided X, Y, Z. X is wrong for this reason, Y is wrong for this reason, and Z is wrong for this reason. And then the judge will make a decision on that.
Okay.
At that hearing, and can, if the judge thinks that the Home Office have actually got it wrong, then the judge has the power to grant the visa.
We've got a question which is not related to spouses, but it's somebody you should love as much as, if not more so, depending on who is mothers. So what do you do if you want to try and bring your mother to the United Kingdom to settle? Now, we haven't been given the age, but let's just assume somebody who is not feeling very well, is in their possibly 60s or 70s. how easy is it or difficult is it for some, given the migrant community we have, to apply successfully to bring a parent, assuming the other parent has passed away, for argument's sake? So I'll give the example, one living parent, they have one sister, say, we mentioned Pakistan, let's carry on with Pakistan, but it could equally be as Bangladesh, Nigeria, Egypt, India, wherever else it might be. One living parent, very old, nobody to look after them. What do they have to show to try and get a visa to come and join their UK-based spouse? If you know, if you don't, we'll have to quickly Google it. No, joking.
No, it's fine. It's not a problem. I know the answer. So what you're talking here really is about the parent making an application under what's called the adult dependent relative category. And really that category, adult dependent relative, says it all. So any parent of a person who's here in the UK, when I say person who's in the UK, we're talking really people who are British or people who are settled here, or
that's
people
very
who
important.
might be refugees. Yes, that's right. They're only allowed to bring their parents over in very, very limited circumstances. And it is a very, very high threshold, and it's a very specific circumstance. So obviously the parent must be dependent upon the child, upon their child, their son or their daughter, their adult son or their daughter. But that's not enough. It needs to be more. So the parent who's living abroad, okay, has to need day-to-day care because of either some illness or some disability, or generally because of old age. So if the parent doesn't need day-to-day care, when we say day-to-day care, we're talking about doing everyday tasks like shopping for themselves, cooking for themselves, staying clean, taking care of themselves. If they can't do this, then they may be able to come to the UK. But again, that's not the only requirement. Above and beyond that, the sponsor who's in the UK, so the son or the daughter who's in the UK and wants to bring their parent over, has to show that they can't find anybody in the country where their parent is living to take care of them. And also, they can't actually pay somebody in the country in which their parent is living to take care of them. So there's quite a high threshold, a number of requirements to be met there. And in those circumstances, you will be able to bring an adult dependent relative, or let's say your parent, to the UK. But as you can imagine, it's a very, 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 very high threshold. In fact, even if we look at the figures, the number of people coming over under this category is only in the few hundreds per year. So it's a very, very limited number of people that this will apply to.
I think recently doctors who are working in the NHS, I remember, maybe I'm mistaken, asked for the rules to be relaxed because they're so stringent. From what the picture you've painted, it's literally having to climb a mountain and then down the other side again and back up again, carrying a big boulder on your back. I mean, you said they've got to be dependent upon you. Even if they are in need of care, you want to spend money. If they come to the UK looking after them, why don't you spend that money in getting a nurse or a doctor or putting them in an old people's home or whatever it might be? So I'm assuming that when you make an application, you will need a lot of very strong, direct and clear evidence, whether from doctors, whether from experts in the country. They might say, if you've got a daughter living in another city, why don't you go and live there? The answer may be, well, for cultural reasons, my in-laws and my husband will not accept this. So you've got to prove your case, and you've got to get all of this evidence together, as well as letters, witness statements and photographs and so on, to be able to show that this is who I am, this is what I'm suffering from, this is why I need the care of my daughter or son, particularly if it's, for example, a woman. And say, again, take any of the Asian countries where men bathing or looking after women, it's not very dignified, for example, and so on. So it seems like a very high threshold, and it's not surprising, the high burden to cross, that's why so many people don't succeed. So coming back to the issue of the wills and probate, you mentioned that the probate registry is experiencing long delays. Now, is there any way of trying to get something urgent done in the interim? Let's say there are people that are desperately in need of some money or something of that nature. Would there be some way of trying to, distribute some assets or some funds in the interim before you get the grant of probate, or is there no?
Again, it all depends on the specifics of what's available. If the deceased had multiple accounts with multiple different banks, some banks, depending on the value left in the account, will not require a grant of probate, in which case you can ask for the money to be released, subject to obviously filling out the necessary forms. Some banks do make allowances for funeral costs and burial costs to be paid out of a deceased's bank account before the grant of probate, so that may help if that's a sticking point. But ultimately, yeah, it really depends on what's available.
Right. So basically, we're living in a climate where, as you've said, 80,000 people have been recorded as having died in the last year. The excess deaths from any normal year are about 20,000 from what the statistical crunches have come forward with. So there are going to be literally thousands, many possibly tens of thousands of people having to deal with this, the death of a loved one, a parent, a sibling, a partner, a child, or whatever it may be. So they're very testing times. And is wills an activity that only solicitors can do, or are other people licensed to do it, or are there any, dare I say it, type of people to be aware of? Because if you go in a moment of grief and to ask somebody who's not professionally qualified or regulated to deal with it for you, could you end up in a very bad place later on?
There are wills is not a regulated field per se. You solicitors do prepare wills, and solicitors, as you know, we're regulated by the Solicitors Regulation Authority. So we are professionally obliged to ensure that proper advice is given in accordance with the law and the due processes are followed. However, there are other organizations which provide wills and will writers who aren't part of any regulatory body. Someone could even simply go to W.H. Smith and pick up a will off the shelf for £50.
What I'm talking about is the probate aspect, because this is where if people get a kit or DIY or something off the web, may well be compliant, but when they want somebody to help them call in the assets, gather the assets, get the grant of probate, what would you say the pitfalls? Because we've heard of horror stories of people going to people in other areas of law who pretended to be experts and ending up causing a complete nightmare for people.
Well, it's always sensible to seek advice from a properly qualified professional. And my advice would be always go with someone who is regulated, whether it's by the Solicitors Regulation Authority or whether it's by an organization known as STEP, which deals with the preparation of wills, to ensure that the advice you are given is correct, sound advice, and in accordance with the law. The last thing you want is to make a will, and then after you've passed away, for your executors to then discover that the will isn't even validly executed. For example, it doesn't even have the right name, doesn't even have the right date, or doesn't have the requisite number of signatures, or a witness was ineligible because they were potentially a beneficiary of the estate. There's all kinds of reasons why a will could be deemed invalid, which effectively results in the will being not worth the paper that it's written on.
Right. So basically, find somebody who is a professional. If you've got to go to a professionally regulated company like a firm of solicitors, they should have indemnity insurance and everything. They've got a regulatory body. So you've got to come back. Yes. Never pay in bundles of cash. If somebody says to you, give me cash, I'll sort it out, Gov, don't worry about it, time to run. Because you've had the horror stories and so have I. Now, one final question, come back to either Saad or Rahul, whichever one of you wants to take this one. Are the rules to bring over a fiance the same in principle as a spouse? And I'll add a second question to that. What can you do as a fiance, or what can't you do as a fiance, which you could do as a spouse? So in a nutshell, we're coming towards the end of the program, so probably the last question. Which of you guys wants to take it?
Yeah, Saad's field at the moment.
Okay, yeah, no, I'm happy to answer that. Okay, right. So with regards to fiance visas now, there are essentially The purpose of the fiancé visa is to bring over a prospective spouse just for the purpose of getting married in the UK. So you can then switch into the spouse category after the marriage takes place. That's the purpose of the fiancé visa, okay, or what we call the fiancé visa. Now it's a 6-month visa. So basically, to get the visa, you have to show obviously that you are intending to get married, but you have to show that you will get married within 6 months of arriving in the UK. And then within the 6 months of arriving in UK, within the 6-month validity of the visa, you then have to switch into the spouse visa category, which is the one I spoke about. And the requirements, if you apply in the UK after getting married with a fiancé visa, are the same as if you were going to apply from abroad.
Okay. Now, practically, you're making 2 applications. You're going to pay 2 sets of fees. If it's safe to do so, would you say that it's better probably just to go abroad, get married, and apply for the spouse visa? Because once you get the visa, you're not having to wait for months on end, paying extra fees, incurring extra headache, where you can hit the floor running, so to speak, if you get married abroad and come straight in. But if for whatever reason you have to get married in this country, then you've got to pretty much prove most things that you'd have to prove as a spouse. Now, the link to this is another question which says that, is meeting once enough with a history of online relationship? Well, that goes to the issue of the subsisting nature of the relationship. The answer to that would be possibly, depending on who's assessing your application, right?
Yes, that's correct. Now, when I was talking about my relationship and applying for the visa, you're right. Included within the genuine, the general requirement of having to show that you're married is the requirement that the relationship is genuine, obviously, because if it's a made-up relationship, that doesn't count for the purpose of this visa application. Now, here, culture plays a big part. Okay, so let's give a few examples now. If you were in the UK, okay, and if you were a normal, let's say, English or European person, the culture there generally is that you have a long-established relationship before you get married. I know sometimes people get married very, very quickly, but there is always what we call a courtship, which takes place before the marriage takes place. The marriage is usually the end of the story rather than the beginning. And in those circumstances, if you only had a little bit of evidence, one meeting, it may not be accepted as being genuine because it's not in accordance with the cultural norms. Now, contrast that with maybe Islamic countries or cultures elsewhere, where actually the marriage ceremony is the beginning of the relationship. And then everything, all the courtship, everything takes place after that takes place. In such a culture, meeting once may not be a hindrance, but it's all about proving that generally the relationship is genuine. So even if you have met once, but you have a good reason for it, there are cultural reasons for it, and there is evidence of an ongoing relationship, and you can see it moving forward into a marriage, then the fact that you've only met once before marriage may not be a hindrance.
Okay, so I think the questioner says about having an online relationship. Well, the key thing is documenting something, but make sure it's not contrived or obviously looks like you're doing something for the purpose of showing somebody else. There has to be a genuine pre-marriage sort of discussions, talk, and comments between each other. But yes, when you get engaged, there has to be a natural human relationship which unravels on your WhatsApp or your Facebook or however you communicate. And after you marry, then just to complete, you need to spend a sufficient time together. There should be photographs and cards and so on. And don't do what I remember in the past where somebody brought lots of photographs wearing the same clothes, but all in different locations, and said, oh, either you've only got one set of clothes or these look like they've been taken on the same day in different locations. There's a rather obvious gotchas or dead giveaways. So like with anything, as we've said at the beginning, what we've said today is for the purpose of general guidance only. It is not intended that you should rely upon it without taking further advice, because you may make a mistake. You're quite likely to make a mistake. And if so, obviously, Aman Solicitors Advocates or any of the solicitors here, we do not take any responsibility should anybody rely on any of this and then make a mistake. If you think you know what you're doing, that's a matter for you to decide. But we would strongly recommend you make sure you know what you're doing or take professional advice before you make any applications. That brings us to the close of today's show. I hope you've enjoyed it. What we would like is on the Facebook, particularly if you want to send us messages of what you would like covered in the coming weeks and months, it would help us to prepare and to discuss matters which are important to you, which concern you. Today we've discussed the school uniform stroke, the religious observance aspect of that and what you can do, and absences. We've discussed wills and probate, which is quite contemporary. We've also discussed immigration law and the idea of bringing over your spouse. We will look at many of these and other subjects in the coming weeks, and all it remains for me to say, first of all, is to thank my colleagues from right to left, Saad Saeed, Rahil Latif and Adnan Mahmood. Thank you very much for joining us. Jazakallah khair.
Thank you.
Thank you. And I think we've all earned the right to now go and have a cup of tea and relax. Until next week, thank you for watching. And inshallah, I'm going to play the out and off we go. Assalamu alaikum. Goodbye.
Are we off it?